I couldn't believe it. I couldn't believe that actually said that I owed this. It don't make sense. It don't even make sense at all. From January the 26th, 2011, they started harassing me on the phone. That's what they wanted, the first payment. And they was requesting me for $22,000. Then it go on and on and on and on and on. Amount due, $93 a month. $93.36 a month. 2016, 2021, all the way up to 2030 something. February 26, 2031, my last payment, it would be 24 cents. I thought I would never go to court for it because I didn't owe them anything, but they took me down to court. They took me to court for it.
Philadelphia's courts have now launched a new effort to collect what could be billions of dollars in unpaid bail.
Philadelphia's court system says years of leniency in collected fines and bail money have come to an end.
The amount of money owed the courts is staggering, $1.5 billion owed by an estimated 400,000 people.
Some of those debts date back to the 70s, and it may simply be an honest mistake, them being unpaid.
It'll be a financial boon to the city, but Mayor Nutter says they'd be doing this even in better economic times.
We're going to do what we need to do because we want our money.
After this campaign, debt collection firms will go on the hunt and tack on fees. Ian Bush, KYWD News Radio.
In 2009, the Philadelphia Inquirer ran a series of stories criticizing the city of Philadelphia for failing to collect court fees, supervision fees, and bail forfeitures stemming from defendants' contact with the criminal justice system. The paper estimated that 1 in 5 Philadelphians, as many as 400,000 people, owed $1.5 billion in unpaid legal financial obligations dating back to 1971. In response, the city abolished the Clerk of Quarter Sessions, a politically elected office that had been responsible for collecting the money but had been lax in doing so. Instead, the city put the courts in charge of collecting the money.
The court, the first judicial district, was tasked with collection of outstanding fees, fines, and costs, bill judgments, and other court-imposed financial obligations. And that's what we started doing in 2010.
Criminal debt is not like civil debt, which means that there's no statute of limitations on it, so that means the court can come back and collect it anytime they wish. Doesn't matter that 30 years have passed.
The court issued hundreds of thousands of notices to alleged debtors, ordering them to pay up or to enter a payment plan of $35 a month. A failure to pay, debtors were told, could result in a seizure of assets, a freeze on their public benefits, or even incarceration. City officials and judges acknowledged that collecting $1.5 billion would be impossible. After all, an estimated 70% of those who owed money to the courts were elderly, disabled, impoverished, unemployed, or underemployed. But collecting even a few percentage points of that money would be a huge financial help to a city with budget problems.
I'm born Marcus Fitzgerald Hill here in Philadelphia. My father's people go back in Philadelphia at least 6 generations. I've been HIV positive for about 32 years. And what happened was I was sick living in Florida and I came up here for the care. At that time, they were giving people with HIV 30 pills a whop. And you did a lot of throwing up. And my doctor, who I happened to be friends with, told me I better go get some reefer. The officer who arrested me stepped out of the car and told me to sit down, never no handcuffs or anything. I said, well, I have a doctor's note. He said, we can't, we have to process you. So I said, okay, well, it's just a nickel bag of reefer. But I was put in prison for a period of about a month. Probation officer said something about fees to me, but he said, oh no, Mr. Hill, you're gonna be waived. You will not have to worry about paying any of these excess fees or these exorbitant fees. But 10 years later, 12, 13 years later, I get a letter in the mail and phone calls on my phone stating that I owe the city money. I had no idea what they were talking about. I was not aware that I owed money. I was not aware that I was still, I thought all this was done and over with. They told me that I owed them $700 and some odd dollars. Most of the fees were for maintenance fees for the probation officer taking care of me. Eventually, I got a letter saying appear in court. The commissioner asked me a series of questions, what my condition was. You look at me, you couldn't tell, but I had cancer, AIDS, and severe sleep apnea, bipolar, just a whole lot of little things going on in my life. And he said that he didn't have the power to help me. At that time, I had 2 grandmothers. I was taking care of both of them. But any little income I made basically went to making sure that all their needs were taken care of. So basically, they were asking for blood from a stone.
Marcus is a very nice gentleman. However, he's been disabled for a long period of time. He's living on Social Security disability and hardly makes ends meet.
I pay full rent. I have gas, electric, telephone, and then we have to get the medication. And here you have somebody telling you, you have to pay another bill. And if you don't go, I was actually getting very aggressive and serious phone calls from these people from the Judicial Circuit Court saying that all I have to do is press a button and you will go to jail. So that became really serious. Luckily, I was able to get a lawyer for CLS and she helped me. But during the process, I saw people come in there for as much back as 30 and 40 years being charged. And these people had moved on with their lives and $30,000, $40,000 fees. And I just thought, this is just cruel, just cruel.
I just feel that this is another example of just kicking the poor down. The budget is being balanced on the backs of the poor, the working class, and the middle class. And all of this is really not fair.
The last time I got found guilty of a crime was 1982. Economically, my money is deteriorating fast. I'm several months behind in my mortgage. I don't want to lose my house. It's hard without a job. I think that I owe something between $5,000 and maybe $6,000. But right now I'm unemployed. I can't pay anything on.
They come back and they want to beat me over the head, beat me over the head. Now you owe us $81,000. Where am I going to get $81,000 from? Why do I owe you $81,000 and I'm still trying to figure that out? My name is Melissa Gamble and I'm the founder and CEO of an organization, The Time Is Now to Make a Change. It's a resource center for formerly incarcerated and incarcerated females. Where are we going to get this money from? Virtually everybody comes home with nothing. With nothing. Most people give up. They become frustrated and they're like, well, forget it. And then some revert back to the life they had, which is to sell drugs so that they could pay these costs and fines and pay this child support. So who's standing up for our population?
That's a very difficult determination to make as far as who has and who doesn't have the ability to pay. What I would consider sufficient income to pay whatever the amount is may differ in what somebody else may decide. So I think at some point we're going to come up with some standards that we will all need to comply with. I don't think we're there. Other than we have agreed to enter minimal orders, and by minimal I think it's $10 a month in situations where it is established that the defendant may be receiving SSI benefits or any other governmental benefits that aren't sufficient to justify a larger order. But I also have to say that the defendants have any number of opportunities to come in and ask for the order to be reduced and for the payment plan to be reset.
I'm heartened that there are payment plan conferences, and so people are able to go and get into payment plans that are different than what the standard amounts are that people are being asked for. But something that is really troubling to watch is to sit in the courtroom, to watch people explain to a trial commissioner how much they can afford per month, and have that trial commissioner haggle with them. So for instance, you got an elderly guy, on supplemental security income, $698 a month, and food stamps. Those are his only sources of income. Trying to get by. He stands up, has his moment to talk to the trial commissioner, and he says, I really only think I can afford $10 a month. And to hear someone respond to him, you think you could do 15? What are those extra $5 a month really going to mean to the court? I mean, nothing in the grand scheme of things. What is it going to mean to that guy? I mean, possibly a meal, possibly a subway token or two. So it's been difficult to watch the court squeeze blood from a stone here by going after the people who are least able to afford this money.
What brings me here today is the fact that the city of Philadelphia is trying to sue me for $41,750. I was making appearances in court until I couldn't make bail. And during this process of not making bail, I was being held in the correctional facility of Holmesburg, where I was unable to make it to court. I was unable to come because I was in prison. Prison authorities and city officials did not bring me down, or they did not have my name on the bus list to go to court that day. And this is something that was going on regularly in Holmesburg. If the jail was locked down, they wasn't really taking us out. We were supposed to have video conferences with judges and all that. We never had that. It was there, but it was never being used. The laws that said that while you're in prison, you have the right to be transported to and from court. I was not done that. We're now being fined for that, for the city's neglect. So we're being fined for their mistakes.
Another major problem is something that the city used to refer to as the bring down problems. People who were in county lockup or in state lockup, they were supposed to be brought down and be delivered to that courtroom for a hearing. But because left hand wasn't talking to right hand efficiently, it didn't happen. What would happen? The person that was presiding over the courtroom where a hearing was supposed to happen would believe that that person had failed to appear. No record was ever resolved to show that they were incarcerated, and so it wasn't their fault. But none of this ever really got addressed because the courts weren't collecting bail judgments anyway. This being the first time that the courts have really made a meaningful effort to collect those bail judgments, it does matter where you were. Now all of a sudden it does matter. And what brings that to a head is that there aren't prison records. They don't maintain records prior to 1991.
They don't have a record that I was actually in prison, but they have warrants that state that I have served time during the period that they state and I wasn't in prison. But they don't have no record of it.
So what that means is that, in effect, the courts are trying to collect money from someone, saying you have to prove where you were, and the person can't prove it because they can't get their hands on records because those records don't exist.
I recently looked in a file in which my client had some bail judgments, in which the file specifically said, after the fact, oops, we found this guy in a state correctional institution. But did the system try to eliminate his bail judgment? No. So here I am years later trying to help this gentleman get out of a debt that they knew was inappropriate because they themselves had discovered that he was within custody at the time that he failed to appear.
It is the defendant's responsibility to obtain the evidence to show to us that he or she was not able to appear, and that's why he or she didn't appear. However, in most cases, the Philadelphia Prisons does not have any record showing that the defendant may have been in custody prior to 1991. So what we currently do is we review the petition in light of the allegation the defendant sets forth. And if the defendant alleges that he or she was incarcerated, we do check other information that we have. And I think I have said that we do give the defendant a benefit of the doubt. So that's information that's not in a file, could not have been in a file, only the defendant has, and if the defendant brings it to our attention, then we will act accordingly.
So now we're both fighting, trying to put pieces together of a puzzle that's spread out throughout the state, if it's even there. Some puzzles, like a jigsaw puzzle, you got a thousand piece jigsaw puzzle. Over the course of time, you're going to lose 5 to 6 pieces. And if you can't find them 5 or 6 pieces, that puzzle is not even a puzzle no more. It's just trash. So now we're just stuck with this big bill, and we got to fight our way out of it.
One morning, the mailman came to my door, and I opened it up. I said, me, cost of court. I opened it up. It was $65,000 they say that I owed them. And the crazy thing about that is that I've been home for 15 years. I haven't had a conviction in over 20 years. And the first thing that came to my mind was, how in the world can I owe these people any money when they let me off probation, when they let me off parole?
One of the most common things that we hear, and which sparks a good deal of outrage, is, well, hey, I was on probation or parole back in the 80s or the 90s, and my PO told me I was done paying, right? Some people even come in with pieces of paper that they show us that say final payment.
Because it says on here, the fines and costs was paid. Everything is on here, so if they wanted all this money out of me, they should have had all the information that I had brought to court. They didn't have none of that, so right there to let you know that you're just harassing me.
I only owed like $100. I had to pay $35 to get out of prison. Okay, any court costs and fines? None. Well, if I didn't owe that when I came out in 2005, how do I owe it now in 2011?
Best we can understand it, they were given incomplete or false information at the time that their probation or parole cases were terminated, and there still were debts on the books that just were left to sit until the computer dug them back up again, however many years later.
Mr. Mack was one of the very first clients that I represented on a bail petition. Some of the files from his cases going back to 1990 and 1994 were missing, so essentially the court could not prove that he owed the money.
The courts are dunning people based on what they have on a computer screen. It's like if you were to receive a bill in the mail from your credit card company telling you that you owe $10,000 in charges, and you wish to dispute it, and you say, well, show me proof of where I made these charges. And they tell you, well, we don't have anything else except what's in this computer screen, but we're obligated to rely on what we see on this screen. And you have to disprove it. That's sort of what's happening here. What we're actually seeing is that in many of these cases, they don't even have a file at all, let alone all the pieces of paperwork that they're legally required to have in order to substantiate, say, a bail judgment. In the case of all the other types of fines and fees, the law is less clear in terms of what they are required to have to prove it, but common sense would tell you you'd like to see it in paper because errors can happen in computer entry and data entry, and also things can get screwed up when you're transferring a legacy computer system to a current computer system. Unfortunately, they don't have many of these files, or at least they can't locate them, and so that's a real problem.
With the newer cases, it's not an issue. We have the file. With the older cases, because there are retention periods, the clerk of court session may have disposed of those records, and perhaps only certain pleadings were maintained, but certainly not the information that we need, that we think we need, that we certainly feel more comfortable having if we were going to proceed with the bail judgments. What has happened in some of the cases that have been adjudicated, we didn't have a file, for instance. We actually did have the file, but we didn't get it until after the case was disposed, and we can't now undo the order that we issued vacating the order, for instance. So the new process will enable us to determine for sure whether the file still exists or not. And certainly if the file exists, then we can rule on the merits of the case. If the file does not exist, then, as I said, in all likelihood, the petition to reduce, the petition to vacate will be granted.
I found out in regards to that the city was suing me through the county assistance office. When I went to apply to get my daughter's medical This is when this county assistance office had informed me that they could not do anything to assist me at all until I paid or made payment arrangements with the city in regards to $41,000 that I owed.
Mr. Taylor came here originally because he was trying to get TANF benefits for his daughter. He's a single father, and he was being prevented from doing that because he had to get paperwork showing that he was current with his payment plan.
When I couldn't get the money I was paying out of my pocket, it was hard for me to pay out of my pocket because I was barely working. I'm working here, there sporadically, and I was still in school at night. So I was unable to get the medical and stuff that she actually needed. I showed them my county assistance acceptance letter, which showed them that I had no funds available and I'm only able to pay what I can pay, and they put me on a payment plan for $10 a month. Got on the payment plan, county assistance allowed me to get the medical for my daughters that I needed.
I believe that's the first time in his life that he's received those benefits, but he was at a difficult time that he needed them in order to continue to provide for his child.
What we've done, once we were made aware of what was happening, is we've allowed walk-ins. So essentially, if any individual has received a letter indicating that their benefits are going to be stopped or aren't going to be granted, they could just walk right in every day except for Tuesday, and they're able to appear before an OCC officer, and as long as they provide whatever information they have. So if they're receiving SSI benefits, as long as they provide whatever information they have or concerning their income, we will reset and readjust their payment plan so that they can get those benefits.
It makes me angry when I see how painful it is to so many people in this city who have tried to turn their lives around and who are being met with incredible stress and anxiety and fear because of money that was never sought before, that they didn't even know that they owed.
Back in 1995, I was addicted to crack cocaine, and I got arrested for prostitution, selling myself on the street for the drug, for money to get the drug. The last time I was arrested was in 1999. When I got to the jail cell that they threw me in, I wanted to stop. I worked for a retail store, but after a while, they found out I had a criminal background. They got rid of me behind that. You know, this went on for all the jobs I ever tried to get. All of them frowned on me because of my criminal history. That's what I need that pardon for.
Caprice Lackey came to Community Legal Services wanting to file a pardon for a series of minor convictions she had years ago. And while she was waiting for her case to come up, the Board of Pardons notified her that they would not consider her case because she still owed fines and costs.
When I sent them the application, I had waited 4 years to hear from them. I thought I paid it off, but I really didn't. That's what they saying, and that's how they had it documented. So I went down there and I paid it off.
That was quite a bit of money because she is living on SSI benefits, but she is so desirous of getting a pardon and was worried that all the time that she's already waited was going to go to waste, that she managed to scrape together money from other resources, and a person who had very little resources has spent a lot of them paying these supervision fees.
In Pennsylvania, having unpaid criminal debt like costs, fines, fees, bail can be a barrier to getting an expungement. It can be a barrier to getting a pardon, and those are the two primary ways in which people can clean up their criminal records and try and get a fresh start and make themselves employable.
Well, this case here about this money that $42,000 I was supposed to owe, it's stopping me from getting my record expunged right now because it's still in the court system and they still saying that I owe them this, but I haven't heard nothing back from the judge yet. So, like Sharon told me, she can't go further on with it until we hear from them. It's been 5 months now. I want my record expunged, you know what I'm saying? It's been too long now, you know?
That's what the statute says. So the statute, if it says before you get the expungement or before you get the pardon, you need to pay, there's really nothing we can do about that until they're paid. unless the statute were to be changed. We could conceivably negotiate the amount. And I know I've done that in connection with at least 2 bail judgment cases that I could think of, maybe more. So if the defendant knows that's the only thing he or she has, and that's what they want, we're able to, we're willing to, in the right case, work some sort of resolution so we could expedite it.
Mr. Gaines had a number of cases on his record, almost all of which I've gotten expunged by court order because they did not amount to convictions. However, that was the case in which he has these 2 bail forfeitures against him for not appearing. So Mr. Gaines, who's legally entitled as a matter of law to get his expungement, has not had that particular case expunged because of these bail judgments against him.
It's making us suffer more. We have been found not guilty, but there's an amount of money that we have to pay. Why? How much more would you take from me? Right now it's taking a lot from me. How much more are you going to take?
Nobody's saying that the court shouldn't be able to impose reasonable costs and fines and fees on individuals who are sentenced. I think our biggest gripe is that the courts have chosen to go back so far, and yet they can't actually substantiate so many of these debts. The fix there would be to pick a more reasonable date to start from.
I do not think we should go beyond 5 years because it seemed to be a problem after that.
Choose a date where you actually think you have prison records. Choose a date when the court still has its own records.
I don't think we would have a major issue in that, but again, that's not really a court issue per se, it's more of a city issue. We're duty-bound to proceed with every case, and if the city decided that they didn't want to pursue the case, the judgments entered in the 70s or 80s or 90s, I don't think we would have a problem with that.
Finally, there needs to be some sort of affirmative review. Our position has all along been that really the courts should actually have some sort of mechanism in place where they first take a look at the judgment that they're about to try to enforce. Say, do we have the file? Do we have all the pieces that we need?
Is there proof that all the procedural steps were taken? Was a bail forfeiture waived by a judge? Were supervision fees waived by a judge? These are not things that are being examined prior to the courts trying to collect the money. Instead, each person is supposed to come back, do their own investigation, and say, hey, I've got defenses because you failed in the following ways. That's just not right, particularly when the court system is trying to chase down hundreds of thousands of low-income people who don't have the means to fight these judgments against them.
I mean, if the court is going to be charging people with really substantial debts and then assuming that people will speak up if they disagree or if they aren't so sure that the court can prove all of the things that the court needs to be able to prove in order to substantiate the judgment, isn't the burden really in the wrong place?
You know, every time they come up with a budget shortfall, the first persons they look at is the poor folks. It's totally unfair. It's totally unfair.
I'm being sued actually for the rest of my life. You might as well say $41,000 to the city. That's a mortgage. A mortgage which the city won't allow me to have now because they're suing me.
I would like something to be done about this, It's really upsetting me, and it's upsetting a lot of people that's my age, And we don't do the things we used to do no more. We got family, we got kids, we got grandkids,
I take full responsibility for what I've done, but I'd like to move on with my life. I don't want to continuously be beat over the head and beat down. So when I think that I'm doing something good, the city comes again and they try to tear me down. It's something strange about that. It's some strange weeds in that garden.